Welcome back to American Agenda. Well, lawyers for former President Trump say they've been unable to secure bond for the $464 million judgment against him, calling the huge sum a practical impossibility.
Yeah, that is a very large sum of cash to be sitting around here. Joining us with the story, the breaking news story today, national correspondent Mike Carter with the very latest. Mike.
Donald Trump's legal team telling an appellate court on Monday that he is unable to obtain a bond for the full $464 million civil fraud judgment against him, an amount that includes more than $100,000 in interest per day. Monday's concession by Trump's legal team raising the possibility that State Attorney General Letitia James's office could begin to seize the assets of the former president unless the court agrees to halt the judgment while Trump appeals the verdict. Trump's lawyers saying in Monday's court filing that ongoing diligent efforts to secure a bond in the judgment's full amount is a, quote, practical impossibility, adding that those efforts have included approaching about 30 surety companies through 4 separate brokers. Unless the appeals court agrees to either stop the judgment or allow him to post a bond for a smaller amount, Trump's deadline for securing a bond in his civil fraud case is March 25th. The same day, a hearing will be held in Trump's New York hush money criminal case, where a judge will decide if that case will be further delayed after the introduction of more than 100,000 pages of new evidence. In New York, for Newsmax, I'm Mike Carter.
All right, Mike Carter, thank you so much. We're going to continue discussing Donald J. Trump's legal woes. So first, to do that, we're going to bring in our guests, our legal eagles here. We have Ronald W. Chapman II, federal defense attorney and criminal defense attorney Dwane Cates. So we've got multiple cases we're talking about here, but first, Ronald, I want to get to what we just heard from Mike Carter's report, specifically Trump's lawyers saying to get their hands on that nearly $500 million cash amount for the civil fraud case for inflating the value, or allegedly inflating the value of his properties here in New York City. They're saying it's an impossibility. What do you make of this? What's going to happen next? $100,000 a day in interest?
Well, certainly it seems like it's impossible. And here's the issue. Trump can't make it. So what do we do next? Do we start seizing property? Absolutely not. The number of third parties that are going to raise claims and spark litigation as a result of attempted seizure is going to make that not possible. And that's something that you would certainly say to the appellate court to lower this bond amount to something that's practical. The reality is, public interest is we want to ensure people are able to post a bond before they appeal, so they're not doing it for malicious reasons. A lower bond amount should be sought, and the appellate court should absolutely grant that lower bond amount. Trump should be okay after he appeals to the appellate court.
Dwane, to Ronald's point, I think what most Americans, when they are seeing this banner come through that Trump can't find the money for this bond here, which who would have that amount of cash sitting around? I think if the left's goal was to, go after the president, former president financially, they're certainly succeeding here. But will this cause some sort of a bankruptcy for the former president? Also, elaborate more on, will they seize his property?
And I agree with the other guest. I don't think they'll seize the property because there's a bunch of people that are going to raise claims and raise issues, and this will be tied up in the courts for a long time. What they should do is they should reduce the bond to something that Donald Trump can pay, and they should tie up his property so he can't dispose of them, without approval of the court, which would guarantee payment, of the bond if he loses the appeal. I don't think he's going to lose the appeal. I think he's going to win the appeal, and then I think this, if they take his properties and he wins an appeal, it's going to create a gigantic mess.
I think it's a great point. I want to switch gears, Ronald, of course, to the case with Manhattan DA Alvin Bragg. They had asked and got approved a 30-day extension. So now that would be to mid-March. This sounds like it's a good thing for former President Trump. However, his legal team is being inundated with all of these documents, and even more are spilling in. Trump's team wants a 90-day extension. Level set a little bit here. What are you observing? What stands out to you in this case?
So if I'm the judge, here's what's going through my mind. We've got 71,000 documents from the U.S. Attorney's Office that were recently disclosed. Much of this is related to the Michael Cohen investigation and grand jury. A lot of it contains what we would call exculpatory information, stuff that is really, really helpful for Donald Trump. The judge doesn't want to give too much time, but wants to allow defense to review it. Typically, what we would see is this trial date being moved incrementally. Now, if I had to look into my crystal ball, is Trump going to trial even in Manhattan before the election? I'm going to call it, and I would say no. These are a lot of documents, and each document could cause another arm of the investigation for Trump's defense team. They need to have enough time to review this information before trial.
Dwane, I know former President Trump has posted before about his, he feels like he may not get a fair shake from this judge going through this case here. What is fair moving forward? What is fair for the former president and his team to review this gargantuan amount of documents?
I have some cases, and I take cases with this many documents in them, and I usually figure it's going to take me 30 seconds to a minute per page. Okay, so if you're talking 70,000 to 100,000 documents at 40, 50 hours a week, you're looking at 15, 20, 30 weeks just to read the documents. That's not organizing them and going through them and everything. That's just to read them. And they've got to give him time to do that. And again, I think it would be reversible error on the court's part if they force him to trial before he has a chance to look at potentially exculpatory documents. I think that would be an error by the court, and I think that would cause a reversal of the case. They have to give him more time. Now, they don't have to give it to him all in one chunk. They can come back in 30 days and say, Judge, we've gone through this many documents. You know, we're finding stuff that is exculpatory. We need more time. And I think the judge has to give it to him.
Dwane, I want to make this clear. What do you think is fair? How many weeks did you say?
Well, he needs 6 months.
6 months.
Yeah,
Okay. There, some normalcy. That was the answer I kind of was alluding to.
Sounds practical to me.
Yeah, okay. Ronald Chapman, Dwane Cates. Gentlemen, thanks for coming on. We appreciate it.
Thank you.
Okay, the U.S. is